Here. In the previous video, we went ahead and went over acknowledgements. As a matter of fact, we're still going over acknowledgements. The last image that we saw was this image here of a California acknowledgement, and this is the way it's supposed to look, with the exception that there's supposed to be a line there at the top. This is always supposed to be boxed. This verbiage here, and this verbiage certifies that you not certifies it, it's stating that you only verify the identity of the individual who signed the document and not the accuracy or validity of that document. So let's go ahead and move on. A notary public seal and signature cannot be affixed to a certificate of acknowledgement without the correct notarial wording. The first part of the certificate of acknowledgement indicating in what county the notary public and person making the acknowledgement are located is the venue statement. The venue statement establishes where the notary public performed the acknowledgement and where the signer personally appeared before the notary public. The state is always California, since the notary public has jurisdiction only within California. And the county should be completed with the name of the county where the signer personally appeared before the notary public and acknowledged the signing of the document. Since a notary public can provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business, or the county where his or her oath and bond are filed, but must be completed with the name of the county where the notarial act took place. The day, month, and year must be completed with the date the signer personally appeared before the notary public and acknowledged signing the document. The notary public must insert his or her name and title, notary public where indicated, and the name of the person who acknowledges their signature on the document after personally appeared. Then the notary public must sign and stamp the certificate with the notarial seal. As stated in the previous video, just go ahead and go on over to quick training videos. We go ahead and exemplify how to fill one of these out. However, this is a venue heading. So county is the county where the signer appeared before you, not the county in which it happens to be your principal place of business. My principal place of business is here in San Diego County, but if I go up to LA County for the weekend, I would go ahead and let's say I'm in LA County for the weekend and I notarize something out there, I would go ahead and write County of Los Angeles because that's where the signer appeared before me. And even though my principal place of business is San Diego County, if the signer appeared before me in LA County, this would say LA County. So this is all about the signer. You would place a date. Before me, you would place your name exactly the way that it appears on your stamp, and you would put notary public, insert name and title of the officer. You're a notary public, so you would put your name, comma, notary public, personally appeared, the name of the signer, and then you would go ahead and fill this section out. Once again, we go over this on quick training videos, so go ahead and refer to that later on or now, whenever you'd like, but please refer to that. We go over this in detail. All right, the notary public must insert his or her name and title, notary public where indicated, and the name of the person who acknowledges their signature on the document after personally appeared. Then the notary public must sign and stamp the certificate with the notarial seal, and here where it says notarial public seal, you would place your stamp above that. Penalties. A notary public who completes a certificate of acknowledgement that contains statements the notary public knows to be false may be liable for civil penalties and administrative action. Additionally, the notary public will be guilty of forgery if he or she issues an acknowledgement knowing it to be false. A person who falsifies the acknowledgement of a notary public may also be guilty of forgery. Forgery is punishable by imprisonment in the state prison or by imprisonment in the county jail for not more than 1 year. False certification by a notary public also may be a misdemeanor. Additional penalties for failing to enter required information in the journal or falsely modifying journal entries are discussed later in this course. Let's use an example. On January 5th, 2016, Abe Signer signs a document for his corporation at Abe's corporate office in San Joaquin County. On the same day, Abe then takes the document to Nancy Notary to have Abe's signature notarized. Nancy first must establish Abe's identity. Nancy establishes Abe's identity by checking Abe's driver's license issued by the California Department of Motor Vehicles. In front of Nancy, Abe acknowledges that it is Abe's signature on the document. Nancy then needs to fill out the journal. Nancy's journal must include the date, the time, and the type of act. Nancy needs to have Abe sign the journal. Nancy also needs to make an affirmative statement in the journal that Abe's identity was based on satisfactory evidence and that the evidence Abe presented Nancy with was Abe's driver's license issued by the California Department of Motor Vehicles, Abe's driver's license number, and the date of issue or expiration date of the driver's license. Nancy enters the fee charged for the notarial act. Last, Nancy fills out the certificate of acknowledgement as shown below. Nancy enters the name of the county where Nancy and Abe are physically located, the date of the notarial act, January 5th, 2016, Nancy's name and title, and Abe's name as it appears on Abe's ID. Nancy then signs the certificate, stamps it with Nancy's seal, and attaches the certificate of acknowledgement to the document. So here is an example of how that should look. The county, San Joaquin, because that's where they are physically at during this notarization. They put the date. She put Nancy Notary because that's her name, and she is a notary public. And personally appeared Abe Signer, who proved to me on the basis of satisfactory evidence to be the person whose name is subscribe, blah, 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 blah. And like I said, refer to that other video. We'll show you how to cross these out, the proper way to cross those out. Okay, so and then lastly, Nancy Notary would go ahead and place her seal right here. All right, moving on. We are now moving on to jurats, which is the second most frequently performed notarial act. And you also administer an oath or affirmation when completing a jurat. A jurat is a notarial certificate attached to a document when a person signs a document and swears under oath or affirms that the contents of the document are true and correct. The notarial certificate for a jurat is identified by the wording subscribed and sworn to or affirmed. The jurat also typically will be found at the end of the document, much like the acknowledgement. A document containing statements sworn or affirmed by the signer to be true and correct typically is referred to as an affidavit or declaration, and the signer will be said to be subscribing and swearing or affirming to the contents of the affidavit. A jurat must be attached to or located at the end of all affidavits subscribed and sworn or affirmed before the notary public. A notary public cannot attach or complete a jurat if the signer of a document does not swear or affirm to the truth of the contents of the document. So by completing a jurat, the notary public certifies the following: that the signer personally appeared before the notary public on the date indicated and in the county indicated, to the identity of the signer by satisfactory evidence, that the notary public administered the oath or affirmation, and that the signer signed the document in the presence of the notary public. And to perform an oath or affirmation in jurat, a notary public must do the following: confirm the identity by satisfactory evidence, of course, the person signing and swearing or affirming to the affidavit. You must administer an oath or affirmation, watch the signer sign the affidavit. You must complete a journal entry for the transaction, and complete and attach a jurat to the affidavit, or complete the jurat affidavit. So you must examine for completeness, just like the acknowledgement. You have to do the same with the jurat. A document executed with a jurat should not be signed before the document is presented to the notary public, because the signer must sign the document in the presence of the notary public. So this one is different in the jurat. I know in the acknowledgement we said earlier that you could, the signer could sign it before presenting it to the notary. That's only with acknowledgements, as we stated, but the jurat, obviously that rule does not apply. The jurat, they must sign in front of the notary public. So there's no ways around that. It's not like the acknowledgement. The acknowledgement they could sign beforehand, just acknowledge that they signed it, and the notary could still notarize it. But with the jurat, the signer cannot sign beforehand. So with the jurat, the signer cannot sign before appearing before the notary public. A jurat should not be signed before the document is presented to the notary public, because the signer must sign the document in the presence of the notary public. Also, the date of signature for the signer of the document should not conflict with the actual date the signer appears before the notary public to obtain the jurat. Best practices tip: visually scan the document for completeness. This is what I was talking about. Just like the acknowledgement, the jurat, you have to scan it and make sure that it's completed. Make sure that there are no blank lines or spaces for data to be entered at some later time. So confirm identity. A notary public must confirm that the person signing and swearing to an affidavit is the person described as the signer in the document. A notary public must confirm the identity of the signer of the affidavit by obtaining satisfactory evidence, of course. In fact, a notary public must confirm the identity of the signer of the affidavit in the same way that they confirm the identity of a person obtaining an acknowledgement. The signer's identity may be established by the oath of affirmation of one or two credible witnesses, or the signer may present one of the identification documents as stated in California Civil Code section 1185B3 and B4. All right, C. Administer oath or affirmation and witness signature. A notary public must always administer an oath or affirmation before completing a jurat. Generally, the notary public obtains the oath or an affirmation under penalty of perjury from the witness and the matters stated in the document are true, Although there is no prescribed wording for the oath or affirmation to be administered by a notary public outside of a civil or criminal proceeding, an acceptable oath or affirmation would be as follows. Do you solemnly swear or affirm that the contents of this document are the truth, the whole truth, and nothing but the truth, so help you God? Or do you solemnly swear or affirm under penalty of perjury that the contents of this document are the truth, the whole truth, and nothing but the truth? So in this second example that we show here, obviously there's plenty of atheists amongst us, and we have to respect everybody's opinion. And so we would go ahead and replace, we would just take out the word God. Do you solemnly swear or affirm under penalty of perjury that the contents of this document are the truth, the whole truth, and nothing but the truth? So this here is just an example because as California law, the California law does not have a specific oath or affirmation that the notary has to follow. So, it just has to be something along the lines of this, but there is no specific language that a notary public has to follow to give an oath. So after the signer swears or affirms to the truth of the contents of the document, the notary public must watch the signer sign the document. A notary public cannot complete or affix a jurat to a document mailed or otherwise delivered to a notary public for which the signer did not personally appear. Take the oath or affirmation and sign in the presence of the notary public in any circumstances, even if the notary public knows the signer. Let's go ahead and move on to the journal entry. A notary public must record the following details in their sequential journal entry about every oath or affirmation administered and jurat given. So this is basically the same thing as the acknowledgement. We have to put it in our log. We have to put it in our notary public journal, log journal, whatever you want to call it, ledger, public ledger. And this is what we have to put in that journal entry: time and date of the act, indication that the type of what type of notarial act performed. An indication that the type of notarial act performed was a jurat. The notary public simply can write the word jurat. So you can simply write jurat in there. Do not abbreviate it. Type of document subscribed and sworn or affirmed. The type of document usually will be stated in the title of the document. If the document does not have a title, the notary public may indicate the type of document is a declaration or an affidavit. So be sure to look for the title of the document, write that in the journal. And again, if it doesn't have a title stated at the top, just go ahead and write in declaration or affidavit. And then, of course, you must collect the signature of the signer in your notary journal. And an indication, the notary public obtains satisfactory evidence of the signer's identity. The notary public sequential journal must contain a statement that the identity of a person taking an oath or affirmation for a jurat was based on satisfactory evidence. Details of how the identity of the 1185B3 and B ID document was issued or expires. So just like the acknowledgement, you have to put all name of the credible witness, and the credible witness must sign the notary public's journal, or the notary public must record the type of the ID document, the serial or identity the ID document was issued. During the course, the notary public should obtain the signature of the credible witness and record the information for the ID document of the single credible witness to ensure complete information is available for a public request, a California Secretary of State inquiry, a civil or a criminal subpoena, or a peace officer investigating a crime. So we mentioned this earlier. Please obtain the signature of the credible witness. It's just best practice to do that. You're going to write their information in, their ID information in your book. Be sure to get that signature while you're at it too. And I would even take it a step further and write the type of document that they were a credible witness to, as I mentioned earlier as well. So if public's journal, the notary public must record the name of each credible witness, the type of ID document presented by each witness, the governmental agency that issued each ID document, the serial or identifying number on each ID document, and the date each ID document was issued or expires. You must also write in the fee charge for the notarial act. You must collect a rate thumbprint of the signer if the type of document is a deed, quitclaim deed, deed of trust, or other document affecting real property, aka just any type of real estate documents. I would go ahead and not take the risk and just put in that thumbprint, because unless you remember this, but it's in your best interest to remember this, but this is difficult, even I forget. Other than trustees' deeds resulting from a decree of foreclosure or non-judicial foreclosure or a deed of reconveyance. So you do not have to collect a fingerprint for these. Try and remember that. But for every other document affecting real property, any other type of real estate document, aside from these two mentioned right here, you have to collect the thumbprint. And you also have to collect the thumbprint for any power of attorney documents. So real estate documents, power of attorney documents, always collect the right thumbprint, and you will always be better off if you just collect the right thumbprint for everything when you're out there. But this will be, this might be on the exam right here. Definitely real estate documents, power of attorney documents, they must, you must always collect a right thumbprint. And, you know, the only two documents that you don't have to collect the right thumbprint for is trustees' deeds resulting from a decree of foreclosure or a non-judicial foreclosure or a deed of reconveyance. So yeah, remember that. And that's the same thing for acknowledgement or jurats, same rule. The following is an example of a completed journal entry for a jurat. Very, very, very similar to the acknowledgement. It's the exact same thing, honestly. Only difference is, you know, type of notarization. Instead of acknowledgement, it'll be jurat. But everything else is filled in the same way. You're going to put in your date and time. You know, this happened on February 12th, 2015, 10:30 a.m. It was a type of notarization. It was a jurat. Character or type of instrument. It was a permission to travel. Name of the signer, Jerry Swear. It is recommended that the name of the signer be printed in this space because the signature is not always legible. Identity established by satisfactory evidence. You're going to go ahead and put your fee. You could charge $15 if you'd like. Note, effective January 1st, 2017, fees which may be charged for certain notarial acts have increased. Additional information. If you have any additional information that you want to write in there, you definitely are welcome to. The more the better. Identification details. California Department of Motor Vehicle, California driver's license. I'm going to go ahead and put the number right there, the expiration date, and over here you will collect the signature and the thumbprint. So as I stated earlier, it's pretty much the same for the acknowledgement. The only difference is the type of notarization. This time is a jurat. as we saw in the other example as well for the journal entry, this is usually all on one side of the book, and on the other side it's usually the signature and the thumbprint. It's usually not top and bottom. It's usually this section will all be over here. So it's like one long line across the book. That's usually how it is. All right. So notarial certificate for a jurat. A completed jurat must be attached to the affidavit, or the notary public must complete the jurat included with the affidavit. The jurat must be filled out completely at the time the notary public signs the jurat and affixes the seal. Jurats must be in the following statutory form. If the language differs on a document with a pre-printed notarial certificate for a jurat, it cannot be used, and a separate jurat complying with the statutory language must be attached to the document. A notary public seal and signature cannot be affixed to a jurat without the correct notarial wording. The following specific disclaimer must appear at the top of the jurat. A notary public or other officer completing the certificate verifies only the identity of the individual who signed the document to which this certificate is attached, and not the truthfulness, accuracy, or validity of the document. It must be in an enclosed box, appear at the top of the certificate, and be legible in a font or typeface that is readable and does not impair its readability. So, try and, if you copy and paste and you want to make your own jurat or whatnot, or if you download some from the internet, regardless, you have to make sure that this is legible, that it's not super small. It's very important that the signer does understand that you are not verifying the document, that you are not certifying the document. You are only verifying the identity of the individual who signed the document. So that has to be up there, and make sure that it is in an enclosed box. Has to be enclosed box, rectangle, whatever, but it's got to be enclosed, 4 corners. And this right here is an example of what a California jurat looks like. You got your area for your county, subscribed and sworn. You got an area for your date, name of the person, and an area for your seal and your signature. All right. So we're going to go ahead and go over how to fill out that jurat. This is it. The first part of the jurat certificate indicating in what county the notary public and person taking the oath or affirming are located is the venue statement. This is a venue statement. The venue statement establishes where the notary public administered the oath or affirmation and where the signer personally appeared before the notary public. The state is always California, since the notary public has jurisdiction only within California. The county should be completed with the county where the oath or affirmation was administered and jurat completed, that is, where the signer personally appeared before the notary public, took an oath or affirmation, and signed the document. So again, just like the acknowledgement, in this section here, this line here, you would go ahead and write in the county where the notarization took place, not where your principal place of business is, not where you filed your bond, but where the signer appeared before you, where the notarization took place. That's the county that you're going to write in right there. All right. The state is always California. Since the notary public only has jurisdiction within California, the county should be completed with the county where the oath or affirmation was administered, and jurat completed, that is, where the signer personally appeared before the notary public, took an oath or affirmation, and signed the document. Since the notary public can provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business, or the county where his or her oath and bond are currently filed, but must be completed with the name of the county in which the notarial act took place. The notary public must complete the jurat with the day, month, and year that the signer personally appeared before the notary public, took the oath or affirmation, and signed the document, and the notary public must enter the name of the person signing and swearing to the truth of the document where indicated after the word by. Then the notary public must sign and stamp the jurat with their notarial seal. All right, let's go ahead and look at jurats for documents with birth dates and age. A notary public cannot certify copies of vital records. such as birth, marriage, or death certificates. Let's repeat that. A notary public cannot certify copies of vital records such as birth, marriage, or death certificates. However, a notary public can administer an oath or affirmation and give a jurat for an affidavit that states the birth date or age of the affiant or includes a photograph of the affiant and or fingerprints or thumbprints of the affiant. In effect, a signer can certify their own vital information by swearing to the contents of a document containing that information. If the notary public gives a jurat for a document that includes the signer's birth date or age and a photograph or their finger or thumbprint, the notary public must require the signer to verify their birth date or age by showing a certified copy of their signer's birth certificate or an ID card or driver's license issued by the California DMV. All right, let's go ahead and look at this example. Paul Jones and his children formed a small family company to distribute the products they made at home. On July 1st, 2016, Paul wanted to get a bank loan, so he went to Nancy Notary again. Here we go with some more Nancy Notaries. So he went to Nancy Notary, who was located in Monterey County. Paul brought a copy of a family document that showed Paul's age and a thumbprint. This document would be part of Paul's loan application. Nancy administered the oath or affirmation to Paul and examined a photocopy of Paul's birth certificate. Nancy could not complete the jurat, though, until Paul returned on August 3rd, 2016, with a certified copy of the birth certificate. Nancy re-administered the oath or affirmation and completed the jurat. Nancy also entered Paul's information in her sequential journal, including the fact that Paul presented Nancy with a certified copy of Paul's birth certificate for review. Let's go ahead and look at an example of what that jurat would look like. State of California. It's always the state of California. County of Monterey, because that is where the notarization took place. Subscribed and sworn to or affirmed before me on this 3rd day of August 2016. That is the day that the notarization took place by Paul Jones. That's the signer's name. Proved to me on the basis of satisfactory evidence to be the person who appeared before me. Nancy Notary would then place her seal right here. All right. Let's talk about proof of execution by a subscribing witness. If a person, the principal, has signed a document but cannot personally appear before a notary public, another person, the subscribing witness, can appear on the principal's behalf to prove the principal signed or executed the document. This method of proving the person who signed a document is the person, This method of proving that the person who signed a document is the person described as the signer in it is called a proof of execution by a subscribing witness, or simply proof of execution. A proof of execution proves the identity of the principal, the person who has signed a document. A principal cannot swear to the truth of the contents of a document by means of a proof of execution. A proof of execution by a subscribing witness cannot be used in conjunction with any power of attorney, quitclaim deed, grant deed, other than a trustee's deed or a deed of reconveyance. And remember, these two are the ones that you do not need a thumbprint for. What are those again? Trustee's deeds or a deed of reconveyance. You don't need a thumbprint for those. But mortgage, deed of trust, security agreement, or any other instrument affecting real property, those, let's go ahead and reread this because I want to make sure that we remember this. A principal cannot swear to the truth of the contents of a document by means of a proof of execution. A proof of execution by a subscribing witness cannot be used in conjunction with any power of attorney, quitclaim deed, grant deed, other than a trustee's deed or deed of reconveyance. So, yeah, you could definitely use it with those. But mortgage, deed of trust, security agreement, or any other instrument affecting real property, you cannot. Also, a proof of execution by a subscribing witness cannot be used on any document requiring a notary public to obtain a thumbprint from the party signing the document in the notary public's journal. So you cannot, to make it simple, you cannot do a proof of execution by a subscribing witness on any document that is related to real estate, of course, with the exception of these two: trustee's deed or deed of reconveyance, or power of attorney. So basically anything in which you will need a thumbprint, you cannot do a proof of execution by a subscribing witness. So remember what those are: real estate documents, with the exception of those two, and the power of attorney. Those you need thumbprints, so you cannot do a proof of execution for those. But by completing a proof of execution, the notary public certifies the following: the subscribing witness personally appeared before the notary public on the date indicated and in the county indicated. The identity of the subscribing witness was established by the oath or affirmation of a credible witness whom the notary public personally knows and who personally knows the subscribing witness. The credible witness presented an identification document satisfying the requirements described in California Civil Code section 1185B3 and B4, and the subscribing witness proved the identity of the principal by stating, under oath or affirmation, the person who signed the document as a party, the principal, is the person described in the document, and 2, the subscribing witness personally knows the principal. 3, the subscribing witness saw the principal sign the document, or in the presence of the principal heard the principal acknowledge that the principal signed the document. And 4, the subscribing witness was requested by the principal to sign the document as a witness, and that the subscribing witness did so. To perform a proof of execution, a notary public must examine the document for completeness, just like anything else, confirm the identity of the credible witness, who the notary public personally knows, by examining an identification document described in California Civil Code section 1185B3 and B4. So remember, even if you know them, you still have to check an ID. Administer an oath or affirmation to the credible witness, swearing to the identity of the subscribing witness. Administer an oath or affirmation to the subscribing witness, swearing the identity of the principal. Complete a journal entry for the transaction, and attach a completed proof of execution certificate to the document. You must examine for completeness. A notary public cannot take a proof of execution of a document that is incomplete. The notary public should visually scan the document, and if it appears to be incomplete, the notary public must refuse to perform the notarial service until the document is completed. However, in determining whether the document is complete, the notary public should ignore information that is intended to be added later, such as information to be placed on the document by a county clerk or recorder, or for additional signers whose signatures are not being notarized by the notary public. Let's go to B. Confirm the identity of the credible witness. A notary public must personally know the credible witness who is proving the identity of a subscribing witness. Also, the credible witness must personally know the subscribing witness who is proving the identity of a principal signer to a document. As described earlier, personally known in California is interpreted to mean having an acquaintance with a person that establishes a person's identity with at least reasonable certainty. An acquaintance substantial enough to establish personal knowledge includes multiple recent meetings with a person, including meetings during which the person is identified by other people. A chain of circumstances that would lead a reasonable person to believe an acquaintance is who they say they are forms the basis for personal knowledge. For example, coworkers have personal knowledge of each other if they meet frequently at their workplace, and colleagues and customers have identified them in the presence of others. A person will not likely personally know an acquaintance whom the person sees infrequently, of course. Even though the notary public will personally know the credible witness, the notary public must still confirm the identity of the credible witness by examining their ID document described in California Civil Code section 1185B3 and B4. So you always have to check for ID, even if you know them. C. Administer the oath or affirmations. After the notary public has established the identity of the credible witness, the notary public must administer an oath or affirmation to the credible witness for the credible witness to establish the identity of the subscribing witness. Under oath or affirmation, the credible witness must swear or affirm that each of the following statements is true. The individual appearing before the notary public claiming to have subscribed their name to a document as a subscribing witness is the person named as subscribing witness in the document. The credible witness personally knows the subscribing witness, and the credible witness does not have a financial interest in the document and is not named in the document. After the credible witness has sworn or affirmed to the identity of the subscribing witness, the subscribing witness must prove the identity of the document signer. To prove the identity of the document signer or principal, the notary public must administer an oath or affirmation to the subscribing witness. The subscribing witness must swear or affirm that each of the following statements is true: that the subscribing witness saw the principal sign the document, or in the presence of the principal heard the principal acknowledge that the principal signed the document. The subscribing witness was requested by the principal to sign the document as a witness, and then the subscribing witness did so. All right, so how would we write all that information in our journal entry? A notary public must record in their sequential journal the following details about every proof of execution by a subscribing witness. You must always write in the time and date of the act. Write in the time of notarial act performed. The type of act would be a proof of execution by a subscribing witness. You would write in the type of document. The type of document usually will be stated in the title of the document. If the document does not have a title, ask the subscribing witness to describe the purpose of the document and record the subscribing witness description in the journal. All right, here's a best practice tip. The name of the principal should be included. Signature of the subscribing witness. Best practices tip. The name of the subscribing witness should be included, but only the signature is required. The name of the subscribing witness should be included, but only the signature is required. Name, signature, and identification of credible witness. The notary public must obtain the signature of the credible witness or must record the type of identification document presented by the credible witness, the governmental agency that issued the ID document, the serial or identifying number on the ID document, and the date the ID document was issued or expires. Best practices tip. The name, signature, and ID of the credible witness should be included. The fee charged for the notarial act. So here's an example of what that would look like. Date and time, November 11th, 2015 at 11 a.m. The type of notarization is a proof of execution by a subscribing witness. The character or type of instrument is articles of incorporation. Name of the signer, Sam Sub. Subscribing witness. It is recommended that the name of the signer be printed in this place because the signature is not always legible. And the identity was established by Chris Credo, and he is a credible witness. Fee is only $10. And remember, guys, effective January 1st, 2017, the fees, which may be changed for certain notarial acts which may be charged for certain notarial acts have increased. Yes, they definitely have increased. And before that, before January 1st, 2017, it was $10. It was 10, and then it went up to 15 January 1st, 2017. And there has not been an increase since. Additional information. Belinda Busy is the principal, and it is recommended that the name of the principal be included. As you can see, there is a credible witness signature. Identification details: California Department of Motor Vehicles driver's license for Chris Credo, and his expiration date, which would be August 8th, 2019. So he's got like a year to go. Then here we have the signature for Sam Sub, because he's a subscribing witness. And then we have the thumbprint section. So proof of execution certificate. any certificate for a proof of execution by a subscribing witness taken in California must be in the following form. Other formats with similar wording are no longer acceptable. Effective January 1st, 2017, fees which may be charged for certain notarial acts have increased. I have said that plenty of times, but you must know that the fees have increased. I'm sure that was one of the first things you learned when you were researching Notary, was how much money do they make. And the fee allowed to charge per notarized signature is $15 at the moment. The following specific disclaimer must appear at the top of the proof of execution. And that is this disclaimer here that we have already read in this course, and it must be in an enclosed box, appear at the top of the certificate, and be legible in a font or type space that is readable and does not impair its readability. So remember, it has to be enclosed. It's either got to be like a rectangle like this. It says enclosed box. So yeah, just make sure it's got its four corners. Make sure it's legible, readable for everybody. You know, sometimes we have signers that have glasses and they can't read small fonts, so gotta make it big. All right, so this is what that form would look like. Go ahead and take a look at it. Okay. The first part of the certificate indicating in what county the notary public, subscribing witness, and the credible witness appeared before the notary public is the venue statement, just like the jurat and the acknowledgement. This is a venue. The venue statement establishes where the notary public performed the proof of execution, which is where the subscribing witness and credible witnesses appeared before the notary public. The state is always California for notaries public, since California notaries public have jurisdiction only within California. The county is the county where the proof of execution was performed. That is where the subscribing witness and credible witnesses personally appeared before the notary public, swore on oath or affirmed, and provided proof of execution. Since a notary public may provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business, or the county where his or her oath and bond are filed, but must be completed with the name of the county in which the notarial act took place. The day, month, and year must be completed with the date the subscribing and credible witnesses personally appeared before the notary public. Next to or in place of name and title of officer, write the name of the notary public and notary public. The name of the subscribing witness must be completed where indicated after the words personally appeared, and also where indicated in the first blank line of the second paragraph. The name of the credible witness must be inserted where indicated after the words on the oath of. The name of the principal, the person signing the document who has not appeared before the notary public, but told the subscribing witness that he or she signed the document, must be inserted where indicated after the words saw heard, and also where indicated after the words at the request of. Then the notary public must sign and stamp the certificate with their notary seal. Okay. Let's go ahead and so we will have an example of that, because I know that was like a lot of information to take in, but here is an example, but we'll get to that right now. Let's go ahead and read this situation. Let's see how this would go down. So the principal, Paul, wants to have his signature on a document notarized. Paul is in the hospital and cannot appear before a notary public, so Paul asked a longtime friend, Sue, to visit the hospital and act as a subscribing witness. And guys, before we go any further, I want to say that this scenario is the most unlikely scenario of all the scenarios presented in this course. And this law is here. It definitely is very useful. You can use it. It's very likely because, even in this example right here, Paul is in the hospital and cannot appear before a notary public. With the number of mobile notaries that we have today and the fees that we're allowed to charge, it is very convenient and lucrative for a notary to go to a hospital. And it's also in Paul's convenience in this example to have a notary come to the hospital. But let's just pretend that there is absolutely no way that Paul can get a hold of a mobile notary public, and let's see how Paul would get this notarized. So let's read this example again. So the principal, Paul, wants to have his signature on a document notarized. Paul is in the hospital and cannot appear before a notary public. So Paul asked a longtime friend, Sue, to visit the hospital and act as a subscribing witness. When Sue comes to the hospital, Sue must watch Paul sign the document. If Paul has signed the document prior to Sue's arrival, Paul must say or acknowledge to Sue that Paul signed the document. Then, Paul should ask Sue to sign the document as a subscribing witness, and Sue must do so. Next, Sue must take the document to a notary public. Sue chooses Nancy Notary. What's up, Nancy? As a notary public. Sue must bring a credible witness with her to see Nancy Notary, the notary public. Sue chooses Carl, a longtime friend, and as a credible witness because Carl has worked with Nancy Notary for several years. Therefore, Carl can act as Sue's credible witness. Sue and Carl appear before Nancy. Nancy determines Nancy personally knows Carl and also examines Carl's California driver's license to establish Carl's identity. Then, Nancy puts Carl under oath. Under oath or affirmation, Carl swears or affirms that Carl personally knows Sue, that Sue is the person who signed the document as a subscribing witness, and Carl does not have a financial interest in the document signed by Paul and subscribed by Sue, and is not named in the document signed by Paul and subscribed by Sue. Then Nancy puts Sue under oath. Under oath, Sue swears or affirms Sue personally knows Paul and that Paul is the person described as a party in the document, that Sue watched Paul sign the document or heard Paul acknowledge that Paul signed the document, that Paul requested Sue sign the document as a subscribing witness, and that Sue did so. Sue signs Nancy Notary's public journal as a subscribing witness. Carl must sign Nancy Notary's public journal as a credible witness, or Nancy must record in the journal that Carl presented a California Department of Motor Vehicles driver's license, the license number, and the date the license expires. Nancy completes Nancy's Notary public journal entry. Nancy then completes a proof of execution certificate and attaches the proof of execution certificate to the document. Sue takes the notarized document back to Paul. And this is an example of what that would look like. So I'm going to go ahead and leave this here for a minute and just go ahead and review that because it's a lot to take in. And again, this scenario is highly unlikely, but you must know this for the exam. Okay, let's go ahead and move on. This is what that would look like as a journal entry. There's your date and time. Type of notarization would be proof of execution by subscribing witness. The type of instrument, interspousal agreement. Name of the signer, Sue Smith, subscribing witness. It is recommended that the name of the signer be printed in this space because the signature is not always legible. The identity was established by Carl Creed, and he was a credible witness. We already know this. Additional information: Paul Prince, the principal, it is recommended that the name of the principal be included. And then here's a credible witness signature. Identification details: his DMV, driver's license number, his signature, his thumbprint. So here's a signature by Mark. A person who cannot write his or her name still can acknowledge his or her signature on a document. So this section right here is signature by Mark. It's very important. And if you become a mobile notary, you will come across a lot of situations where the signature by Mark is very useful. A lot of elderly people, sometimes even individuals that have been in an accident and they can't use their hands. They can't always write in their signature the way they used to on their ID, the way it appears on their ID, and so, or sometimes it is on their ID the same way. I just notarized an individual who on their ID they just literally had a line. Now, while that would look like a signature by Mark, that is technically their signature now. It is unusual though. And the reason I bring that up is saying that, sometimes as people get older, it just becomes harder for them to do things such as signing a document, even something as simple as that. So this is a great tool, signature by Mark. And, often signatures just don't come out the same. Sometimes they're barely legible. And that's where this signature by Mark comes in. As long as they try, as long as they're that it's them and they're attempting to sign it, then, that is a signature. But let's go ahead and dive into signature by Mark and what that means exactly. So a person who cannot write his or her name still can acknowledge his or her signature on a document or subscribe and swear to an affidavit by making a mark. To perform a notarization with a signature by Mark, the notary public still performs the steps required for the appropriate notarial act, such as an acknowledgement or a jurat. The notary public must use the appropriate form as well. The notary public must confirm the identity of the person making the mark by satisfactory evidence. The notary public also must perform the following additional steps. If the signer must acknowledge his or her signature on a document, the signer can make a mark where his or her signature should be in the presence of a notary public, or can acknowledge that the mark in the place for a signature is his or her mark. Note that the mark does not need to be an X. It doesn't need to be an X. If the signer is subscribing and swearing to an affidavit, the signer must make a mark where his or her signature should be in the presence of the notary public. Note, the mark does not need to be an X. And, they really stress that because, sometimes, like I said, the individuals, the signers, they attempt to sign and it just, sometimes it just comes out like a line and or squiggly line or something, and that will be a signature by Mark. 2 witnesses must observe the signer making their mark and must sign their names next to the signer's mark on the document. One of the witnesses must write the name of the signer making the mark next to the signer's mark. The signer also must take his or her mark as a required signature in the notary public's journal. The making of the mark in the notary public's journal must be witnessed by a person. The witness must sign his or her name next to the mark and write the name of the signers next to the mark. The notary public can serve as the witness for the signer's journal signature. The witness only are verifying that they witness the individual make his or her mark. A notary public is not required to identify the 2 persons who witnessed the signing by Mark or to have the 2 witnesses sign the notary public's journal. So the 2 people that witnessed the mark, they do not have to sign your journal. That's something that they don't have to do, and you can serve as a witness in the notary journal. Exception: if the witnesses were acting in the capacity of credible witnesses in establishing the identity of the person signing by Mark, Then the witness's signatures must be entered in the Notary Public Journal. Following are examples of a jurat and journal entry for a signature by mark. So let's go ahead and look at how this would look in a journal entry. I, Bob Smith, have been a resident of California since November 14th, 1977. This is the way the form would look like. So that is his signature right there. And the witness wrote Bob Smith right next to his signature by mark, thus making the mark. And then the witnesses write their names right next to Bob's signature. Witness number 2. So they write witness and witness number 2. Okay, this is just a jurat. And this is how the journal entry would be for that. So the date, type of notarization is jurat. The character or type of instrument is an affidavit. The name of the signer is Bob Smith. Identity established by satisfactory evidence, because you still looked at an ID. Additional information, you have to write in that the signature was made by a mark. The identification details right here, and the signature. There's Bob right there with his signature by mark, and then he would print his name. And then let's say you did have a witness and it wasn't you would just go ahead and write the witness's name and write witness under it. So let's go ahead and move on to certifying copies. A notary public can certify the copies of only a few types of documents. The notary public only can certify copies of powers of attorney, copies of his or her sequential journal or portions of the journal in response to a written request of the California Secretary of State or a subpoena or court order. Certified copies of birth, fetal, death, and marriage records can be made only by the state registrar, by a duly appointed and acting local registrar during their term of office, and a county recorder. To certify a copy of a power of attorney, a notary public must compare the original power of attorney document and the copy to make sure the copy is exactly true and correct, or make a copy of the original power of attorney document. Attach a notarial certificate to the copy stating that the copy is a true and correct copy, and complete a journal entry. So this is what that certificate would look like. A suggested form of notarial certificate for certifying a copy of a power of attorney is shown below. All right. The first part of the certificate indicating in what county the notary public and person requesting the certified copy are located is a venue statement. The venue statement establishes where the notary public performed the certification and where the person requesting the copy appeared before the notary public. The state is always California, since the notary public has jurisdiction only within California. The county is the county where the certification was performed. So that would be right there. That is where the person requesting the certified copy personally appeared before the notary public and presented the original power of attorney for a certified copy. Since a notary public may provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business, or the county where her oath and bond are filed, but must be completed with the actual county in which the notarial act took place. The notary public must insert his or her name and the day, month, year, and person requesting the certified copy personally appeared before the notary public, and the notary public compared and certified the copy of the power of attorney. Then the notary public must sign and stamp the certificate with their notarial seal. So here we have B, journal entry. A notary public must record the following details in their sequential journal each time the notary public certifies a copy of a power of attorney. Here we have a best practices tip. To ensure completeness for a later request for information related to this type of transaction, the notary public should also record the name of the person who is requesting the certified copy, the name of the agent appointed by the power of attorney, and the person who signed the power of attorney, aka the principal. You must also write in the time and date of the act, just like any other notarization, the type of notarial act performed was certifying a copy of power of attorney, and the fee charged for the notarial act. Here we have an example of what that would look like. You have your date, type of notarization is certified copy of power of attorney. The character or type of instrument is power of attorney. Name of the signer is Peter Price, principal. Andrew, sister, is the agent. And it is recommended that this information be captured. So yeah, so you should write in who the principal of the power of attorney is, and that's the signer. And the person receiving the power of attorney would be the agent, so you should write their name in too. Andrew's sister. And the identity was established by, we don't need to fill that in. Your fee. Additional information, the copy was requested by Bob Lohner, bank manager, First City Bank. So yeah, so you have to, it is recommended that you write in who requested this copy, certified copy of power of attorney, and who the principal was in that power of attorney, and who the agent is. The identification details, no. All right. Immigration documents, section 7. A notary public can notarize the signature on a document affecting the immigration or citizenship status of any person. The notary public cannot assist a person in completing any immigration document except for the signature and date. Only an attorney, a representative accredited by the U.S. Department of Justice, or a person who is registered by the California Secretary of State and bonded as an immigrant consultant under the California Business and Professions Code, may assist a client in completing immigration forms. Only an attorney can advise a person regarding which immigration document or form the person should complete, or advise how the person should answer questions posed by an immigration document or form. If a notary public is also a California registered immigration consultant, that notary public may assist a client by inserting the answers given to the consultant by a client. A notary public who is also a registered and bonded immigration consultant may charge $15 per person for completing a set of immigration forms. A notary public also can charge an additional fee for each notarial act performed in relation to a set of immigration forms. Please note that special rules apply to notaries public who are also immigration consultants or advertise their services in a language other than English. A notary public is barred from advertising in any manner whatsoever that he or she is a notary public if the notary public also promotes himself or herself as an immigration specialist or consultant. A notary public who is not a licensed California attorney and advertises notarial services in another language other than English must post with the advertisement, both in English and the other language, that the notary public is not an attorney and cannot give legal advice about immigration or any other legal matters. The notary public also must list the statutory fees that a notary public may charge for notarial services. In many countries outside the United States, an individual must be a duly licensed attorney before he or she may obtain a notary public commission. In Latin American countries, the phrase notario público implies that the person is a practicing attorney in that country, which is not the law in the state of California. So, under California law, a person may be appointed and commissioned as a notary public without being a licensed attorney. Therefore, a notary public cannot translate the term notary public as notario público or notario into Spanish, even if the prescribed notice is posted. A first offense for a violation of this law is grounds for the suspension of the notary public's commission for not less than 1 year or revocation of a notary public's commission. A second offense is grounds for the permanent revocation of a notary public's commission. So this is really important. Personally, I have heard of people that came from Latin American countries specifically, and they were under the impression that a notary public was an attorney, and so there was like cases where notary publics were charging these ridiculous amounts of fees for these. They were basically just acting like attorneys, and let's say an individual walked in and they requested some type of legal document and these notary publics would charge a large amount of money and disappear with the money. So I'm not sure if exactly that's where it derived from. I'm assuming because I've heard plenty stories such as that, and they would use this phrase, and this is what would trick people into believing that they were attorneys or that they were practicing law. And no, that is not the case in the state of California. So you get in big trouble if you don't follow those rules. So here's one example. Catherine Consultant is a notary public and has been registered and bonded as a California immigration consultant. Mikhail and Irina visit Catherine, to obtain assistance in completing citizenship forms. Catherine's business cards say that she is a notary public and an immigration specialist. Catherine enters information into the citizenship forms that Mikhail and Irina provide and enters information she knows from her own experience and education as an immigration consultant. For these combined services, Catherine charges Mikhail and Irina $100. But Catherine has broken a number of laws. She cannot hold herself out as a notary public in her advertising because she is an immigration specialist also. Catherine cannot enter information into immigration forms on her own, and Catherine cannot charge more than $15 per person for completing the forms on behalf of her clients. Catherine can charge an additional notary fee for any notarial services if she limits herself to completing the citizenship forms with only information provided by Mikhail and Irina, but can charge no more than the statutory $15 for each signature notarized. The permitted statutory fees are less than the total Catherine charged Mikhail and Irina. All right, we're going to go ahead and stop this video here. We have a few more sections to go over, but we are way past, more than halfway done at this point. We are on slide 108 of 137. And we pretty much everything is important, but we pretty much went over the more like complex materials of this course. So we're going to go ahead and stop right here, section 8, protest, and we will see you on the next video.